Welcome to our video, Doctor. We are Group 5 and we choose the topic for strict liability with the issue of product liability. Doctor, for your information, we have 6 group members: me, Adam, Khairul, Hatim, Sarmili, and also Wildan.
Hi, my name is Sarmili Munedi, biometric number 8144105. Today I will briefly introduce street liability in context of product liability. Tort law governs civil wrongs outside of contract, and product liability is a key area, especially relevant as we increasingly rely on manufactured goods. When defective product cause harm, the law holds manufacturer and seller accountable. Originally, product liability was based on negligence, require proof of fault. However, with complex production processes, this is often difficult. So, street liability addresses this as allowing claimant to succeed without proving the negligence. There are 4 elements must be proven in street liability claim. First, the product must be defective, either through a manufacturer error, poor design, or failure to warn the consumer. Second one is the defect must have existed when the product left the manufacturer or supplier control. Third, the claimant must prove that the defect caused the injury. This includes both actual and legal causation. The fourth element is the product must have been used in foreseeable manner. If the consumer used in unexpected or reckless way, liability may not be applied. Finally, street liability play a critical role in protecting consumer, encouraging manufacturer to improve safety standard and building public confidence in the marketplace. It also helps distribute the cost of accident across the industry through insurance and internal risk management.
Okay, Doctor. Today I'll briefly explain about a law and legal framework of strict liability and its role consumer protection. Strict liability means that manufacturer can be held legally responsible for harm caused by a defective product, even if there's no proof of negligence. 2 cases, Donghue vs. Stephenson and Brand vs. Australian Printing Mills, establish the idea that manufacturers owe a duty of care to consumer, even without a direct contract. In Malaysia, this principle clearly reflected in the Consumer Protection Act 1999. It shifts the burden of proof the consumer to the producer and makes legal remedies more accessible through the Consumer Claims Tribunal. Additionally, the Sell Good Act 1957 complements the CPA by ensuring goods meet certain standards, although it's applied mainly when there's a direct buyer-seller relationship. Together, this law helps protect consumer and ensure product safety across the market. That's all. Thank you.
I will be presenting the types of product defect under product liability. Types of product defect under product liability consists of 3. The first is manufacturing defect, which occur during the production process. Second is design defect, refers to defect or inadequacy in the overall design of a product. The third is marketing defect, which is involved insufficient warning or instruction regarding the proper use of a product.
Assalamualaikum and hi, my name is Muhammad Khairul Imran bin Hami, matrix number 814129. Today I will be talking about the real case or news example about the strict liability. The first landmark case is the Ryland vs. Fletcher case, where this case established 4 key elements for strict liability. The thing was kept on the land, the non-natural use of the land, the thing escapes, and the damage was foreseeable. This case is about a reservoir that was built on Ryland's land, and the water escaped through old mine shafts and flooded Fletcher's coal mine. However, there was no negligence by Rylands, but the damage was occurred, and the court applied the strict liability, holding Ryland was liable. The second one is Abdul Aziz versus TNB, where a dam water that was managed by TNB released a lot amount of water during heavy rain, and causing flood damages and fatalities. The court applied the Ryland versus Fletcher principles, holding TNB was liable. The third case is Bijnandan Singh versus BMW Malaysia, where the plaintiff got involved in a car accident, and the plaintiff claimed that the airbags failed to deploy due to a defect that existed when the car was sold, and the manufacturer held liable even without proof of fault.
For the next part, I will present the defenses to product liability. So, for the first defenses is contributory negligence, which the claimant is partly liable for their own injury because they failed to take reasonable care when use the product. The second defenses is voluntary non-fit injuria, which the claimant knowingly and willingly accepted the risks while using the product. The third is product used incorrectly, which the party used the product in a way not intended.
Next, for this section, I will be doing a quick comparison between Malaysia and the United Kingdom on how strict liability is applied on their legal systems. So, as you can see on the slide, in Malaysia, strict liability isn't commonly applied. It is mostly governed by statutes like the Consumer Protection Act 1999 and the Sales Good Act of 1957. And the key point here is this, that Malaysian courts usually require proof of negligence. This means that if you want to sue for damages, you need to show that someone did something wrong. On the other hand, the United Kingdom, strict liability is more developed and more consumer friendly. It started with the famous case of Rallins and Fletcher, which laid the groundwork for holding someone liable for dangerous things, escaping from their land, even without proof of fault. Fast forward in the modern times, and the UK's Consumer Protection Act 1987 here, it goes a step further. It lets consumers claim damages for defective products without proving any fault. That is a big deal because it shifts the burden away from the victim. And now in Malaysia, we have seen some exceptions. For instance, in Petronas Gas Berhad and DWZ Industries 2020, the court did apply Rallins and Fletcher when pollution from a factory damaged a gas pipeline. But again, that's more of an exception than the rule. So the takeaway here is Malaysia is still more cautious, and strict liability is applied only in very specific situations. The United Kingdom takes a broader and more protective approach, especially when it comes to a consumer's right. Perhaps it is time for Malaysia to consider moving in this direction too, especially to make it easier for consumers to seek justice without needing to jump through hoops and prove negligence.
So today, I want to highlight the critical role of strict liability in ensuring consumer protection within product liability law. Unlike negligence, strict liability does not require the consumer to prove fault, making justice more accessible, especially in our complex industrialized world. In Malaysia, statutes like Consumer Protection Act 1999 and the Sale of Goods Act 1957 integrate strict liability principles, drawing from foundations like Donahue v. Stevenson and Grant and Australian Knitting Mills. Strict liability target three main causes of the defective products: manufacturing, design, and marketing, thereby pushing the business toward higher safety standard. Yet, it is balanced by defense such as contributing negligence and voluntary injuria, ensuring manufacturers are unfairly penalized. Compared to countries like the UK, Malaysia remains cautious but progressively embrace stricter standards, and moving closer to international benchmark could enhance both consumer protection and legal clarity. Ultimately, strict liability helps build trust, ensures product safety, and support justice, value essential for a fair and responsible marketplace. Thank you.